Hello everyone, thank you very much for watching. This is a series of explanatory videos about German employment law. In this video, we will talk about different legal topics that must be known by the employer and the employee before the contract is signed, specifically during the job application and the job interview. First, we'll see how the equal treatment law affects the hiring process. Second, we'll talk about data protection of the applicant's information. Third, which cost and under which conditions must be paid by the employer. Then, the effects of a rejection. Fifth, which role has the Works Council? And last, details of the job interview. The equal treatment law prohibits some criteria that leads to discrimination based on race, ethnicity, gender, religion, belief, disability, and sexual identity. Once the employer has received the applications, he must save them for at least 3 years, in case a rejected applicant files to be rejected for one of the reasons mentioned above. Here in Germany, it is a common practice to ask explicitly for a photo, but this will never add valuable information about the applicant's skills, and it can always be used against the employer if the applicant files a discrimination claim. The second topic we want to talk about is data protection of the applicant's information. How the employer handles the information received during the recruiting process is very important. He must treat it with a certain level of confidentiality, which means that the application cannot be sent around. If the employer wants to save the applicant's information for further vacancies, must notify the applicant and gather his or her consent. Now, we'll see the cost during the hiring process. The cost for traveling to the interview must be paid to the applicant, unless these are excluded in the interview invitation. On the other hand, the employer has no legal obligation to compensate the new hire for moving. When an employer has decided to reject an applicant, there is no legal obligation to do it written, and neither has the employer the obligation to specify why. Before the contract between the employee and the employer is signed, the Works Council must be informed. Also, the employer must provide the Works Council with all the documents provided by the selected applicant and the ones created by the employer during the selected applicant's recruiting process. Once it has been informed, if the Works Council finds a reason to oppose to hiring a specific applicant, the employer cannot hire him or her unless there is a favorable court decision. By law, the Works Council has no right to attend the job interviews of the applicants. If there is a works agreement that states something different, then the Works Council will be allowed to present the interviews. During the job interview, there are some questions and some requests that are impermissible, and therefore, if the applicant is asked, he or she has the right to not say anything or to lie without legal effect. Some impermissible questions are marital status, pregnancy or desire to have children, reasons for leaving a prior employer, handicap, union or religion affiliation, political party or financial situation. Examples of impermissible requests are SHUFA, since this can reveal personal information. Also, proof of criminal records, unless it can be related to the job. For example, fraudulent acts for cashiers. Physical, medical, and personality and intelligence tests are also impermissible, unless it is justified. For example, side exams for pilots. Last, the employer cannot ask an applicant's old employer about the candidate without his or her permission. Thank you very much for watching. If you have further questions, please leave a comment.